Few policies illustrate the erosion of liberty more clearly than DUI checkpoints. They are the state's sanctioned intrusion into the daily lives of citizens, where searches are performed without cause, suspicion, or apology. In colonial America, such unwarranted impositions were called general warrants and were used by the British to enter any premise looking for smuggled goods. These abuses were a major grievance that fueled the American Revolution. When drafting the Constitution, the founders drafted the Fourth Amendment precisely to prevent this sort of behavior. It reads plainly, "The right of the people to be secure against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause." Yet today, Americans are stopped on public roads not because they are suspected of committing a crime, but because they are convenient targets. Their rights are not violated for cause, but for the mere fact that they happen to be on the road where government agents set up shop. Call it what it is. A DUI checkpoint is a dragnet. It is a warrantless, suspicionless stop, predicated not on an individual's actions, but on their presence. Despite the name, these checkpoints rarely catch drunk drivers in any significant number. What they do catch are expired tags, broken taillights, missed insurance payments, and unpaid tickets, infractions that pad municipal budgets but do little to remove dangerous drivers from the road. To justify this, the courts have engaged in some of the most tortured logic seen in modern jurisprudence. In Michigan, Department of State Police versus Sitz, the Supreme Court held that DUI checkpoints do not violate the Fourth Amendment. Writing for the majority, Chief Justice Rehnquist asserted that the state's interest in preventing drunk driving outweighed the minimal intrusion on motorists. This is a revealing phrase. Minimal intrusion, like reasonable restriction, is a sleight of hand designed to downplay state overreach under the guise of safety. The court's reasoning effectively flipped the Constitution on its head. Rather than asking whether the government has sufficient cause to stop an individual, it asked whether the government has a good enough reason to trample the unambiguous language in the Bill of Rights. This is not constitutional law. This is the denial of it. If we apply this logic more broadly, where does it end? If the state's interest in catching offenders outweighs the inconvenience of the innocent, why not checkpoints at malls, schools, or homes? Why not stop every citizen at random and ask where they've been, what they've bought, and what they're carrying? If the only standard is state interest, unbounded by probable cause, then we are no longer citizens empowered with individual liberty. We are perpetual suspects by default. The practical consequences of these checkpoints should not be ignored. They are ripe for abuse. Officers do not simply check for intoxication. They run plates, demand identification, and inspect vehicles. In minority and low-income communities, the consequences are especially severe. A routine checkpoint can become an arrest, a towing, a fine that snowballs into a license suspension, a bench warrant, or worse. The argument that checkpoints are a deterrent is equally hollow. Studies have shown that patrols, officers actively on the lookout for erratic driving, are far more effective at catching impaired drivers than stationary checkpoints. However, the checkpoints are far more efficient than patrols in pursuing the unspoken goal of generating revenue. That is the dirty secret of modern enforcement. It is often less about law and order than it is about control and collection. DUI checkpoints may catch the occasional intoxicated driver, but their real utility lies in their ability to cast a wide net in order to troll for finable offenses. They are the low-hanging fruit of municipal revenue, rationalized in the name of safety, but functioning as roadside tax collectors. This is not to say that drunk driving is not a serious issue. It is. Lives are lost every year to impaired drivers, and the state has a legitimate interest in preventing such tragedies. But that interest must be pursued within the bounds of the Constitution. Convenience should not be a pretense for the abandonment of principle. We do not surrender liberty simply because it is easier to govern without it. DUI checkpoints may be advertised as a tactic to save lives, but their primary effect is to normalize warrantless searches and condition the populace to accept arbitrary government intrusions as a natural part of life. Checkpoints today may be about sobriety, but tomorrow they may be about something else entirely: guns, political materials, or domestic extremism. The machinery is already in place. The precedent is already set. All that's needed is a new pretense. The Constitution was written precisely for the times when fear and expediency tempt us to trade liberty for the illusion of safety. DUI checkpoints represent a quiet, creeping betrayal of that principle. If liberty is to mean anything, it must include the right to move about freely without being stopped by agents of the state when not a shred of suspicion exists. That is not a radical concept. That is the Fourth Amendment.
Can you say why America is the greatest country in the world?
Freedom and freedom. So let's keep it that way.
I think that the real job that we have that confronts us is to somehow be able to sell our fellow Americans on the moral superiority of personal liberty.
I would remind you that extremism in the defense of liberty is no vice.